Welcome to Practical, Clear Guidance on Business Law, Probate, and Estate Planning with Meents Law.
Welcome back to Practical Clear Guidance on Business Law, Probate, and Estate Planning with Meents Law. Frank Meents helps individuals, families, and small business owners across Northern Illinois with estate planning, probate, and practical legal advice. I'm Lisa Mosby, and today we're tackling a question a lot of people quietly wonder about: whether estate planning actually matters if they don't consider themselves wealthy. Frank, thanks so much for being with me again today.
Thank you for having me. Hello, everyone.
You know, a lot of people assume estate planning is only for those with significant assets. And we touched on this in our introduction, but what tends to get overlooked in this line of thinking?
Sure. Oftentimes, people don't realize the number of assets that they actually have. When you take into consideration retirement assets, life insurance, any kind of real estate holdings, business ownership, whether it be an LLC or an S corporation, stocks and other types of investments that we just accumulate over our lifetime. And the estate plan really will help them distribute that in a manner in which they want it to be distributed, regardless of the size. If it's $100,000 or $100 million, the estate plan is the tool that works.
And sometimes it's not always about just the assets, but responsibilities. Don't we include responsibilities in estate planning in some cases?
That's a great point, Lisa. You have the manager of the estate, if you will. We call it the executor or the administrator of the estate. We have trustees for those estate plans that have trusts. We have agents for helping us make healthcare decisions. We have agents helping us make financial decisions in the event that we're unable to. And then for those who have minor age children, we nominate guardians for our children who would take care of our guardians if something happened to us.
And I think of estate planning oftentimes with families, people who have spouses or children or aging parents they need to take care of. So what about those who are individuals? Is there a difference between family estate planning, individual estate planning? Do individuals need to have estate planning?
Sure. There's really not much of a difference. An individual might have an easier time distributing their property, naming the individuals or the entities that they want their property to go to after they've passed. Some people choose charities that are important to them, which may change over their lifetime, certainly. Others choose family friends, and then others, more distant relatives that you may or may not be that close with. So it's definitely important for those two reasons, naming the people who are going to help us when we can't help ourselves, and then also identifying those people or entities who are going to receive the bounty of our estate, as we say.
And in Illinois, what happens by default if someone passes away without any estate planning documents in place?
So our statute has what's called intestate succession. And that's the term that's used for someone who passes without a will, without a trust in place, nothing of the sort, and they don't name a trustee, they don't name an executor, they don't name a beneficiary or heirs or anything like that. So the state of Illinois has determined that if one of us passes as an Illinois resident and we have a probatable estate, that estate goes to half to our spouse and half to our children. If we don't have children, then everything would go to our spouse. If we don't have a spouse, everything would go to our children. If we don't have a spouse or children living at the time of our death, then our estate would go to our parents and siblings, and then more remote relatives after that.
And we touched a little bit on those decisions besides money and property, responsibility decisions. Can you give me an example of a case maybe where that applied and somebody had included those types of responsibilities in their estate plan?
There's a famous case out of Florida that made this very important, the Terry Chavo case, that um, Miss Chavo was in the hospital and was being kept alive by machines. And Miss Chavo's parents wanted, had been informed by Miss Chavo what she wanted. However, her estranged husband, they were still married. Her estranged husband had power of attorney over healthcare for her because they were still married. If Miss Chavo had made her wishes known in an estate plan, her family would not have gone through the horrendous ordeal that they went to. That was national news, and it ended up causing more conflict between Miss Chavo's parents and Mr. Chavo, the estranged husband.
So, for people who feel healthy and far away from needing this kind of planning, why does timing matter more than they might expect?
The simple answer is we never know. We don't know when we're going to pass. We don't know if we're going to be incapacitated in some way, even on a temporary basis. Does incapacitation can just be from a car accident where you're in a state of mind that you're unable to manage your own personal affairs or make your own healthcare decisions. So once you're able to effectively sign a contract in the state of Illinois at 18 years of age, you want to have a basic estate plan in place. You don't have, most 18-year-olds don't have a lot. However, they do travel a lot, especially those who go away to school, driving back and forth to school. If that's the case, if something were to happen, you want someone to be able to help you with those medical decisions without having to jump through a bunch of hoops with a hospital or doctors or hospital administrators.
Yeah, I think this might be a little eye-opening for some folks. And for listeners who are unsure where they fall on the spectrum, what's a reasonable way to start thinking about whether estate planning should be on their radar? And how do they get started? Who should they talk to first?
Sure. So who should they talk to first? They should talk to an estate planning attorney who is comfortable speaking, who they are comfortable speaking with. It's almost like an interview process. The initial consult, it's a lot of information, and you want to make sure that you trust the person that you're talking to, and that you are comfortable. You're divulging information sometimes to them that you may not even be divulging to your family. So that's the last part of that question. The first part of that question is what you should be thinking about is we typically are trying to answer four main questions when we're talking to clients with estate planning. First one is, who is going to get our stuff when we pass? Where is it going to go? Where are our assets going to go? How do we want them to get there? Do we want it all at once? Do we want it over time? And that's going to vary based on every family situation. The second question that we're trying to answer is, who's going to make sure that our stuff gets to where we want it to go? And that's going to be the trustee, or the executor of our will. And that also has to be someone that you can trust to do the right thing, what you've instructed them to do via your trust or your will, and that they're able to do that. So oftentimes as we get, when we start this process when we're young, we may have a parent or our parents be named as trustees or agents for us. However, as we age, our parents age with us, and maybe they're not the best people to do that any longer. Maybe it's a sibling, or maybe it's one of your own children as we age. So that's the second part that we always address. The third part is, who's going to help us make those financial decisions for us, short of passing, but we're unable to manage our own financial affairs. Who's going to help us with that? Sometimes, but not always, that's the same person as the named executor or the named trustee that answered question number 2. And then the fourth question is that we try to answer is who's going to help us make healthcare decisions in the event that we're unable to do so. And now those are the 4 broad questions. And then each section has, each of those questions has multiple sub-questions, if you will, to ultimately get to the answer and formulate almost your entire estate plan from that line of questioning.
And you mentioned you need to be comfortable with somebody and it's an interview process. Should you actually interview multiple attorneys to find one that fits with? Yeah.
It's always a good idea, regardless of what type of legal matter you have. You want to make sure that they're competent in that area of law. Not all of us are competent in every area of law. I certainly am not. If you came to me for a medical malpractice case, I would tell you need to go somewhere else. I don't know anything about that. So make sure that they're competent in that area of law. And again, that you're comfortable with them. It's not a great situation, even for the lawyer, if the client is not trusting of you or is not comfortable with you. That's not an ideal client for any attorney that I've ever met.
And do attorneys charge for those interview processes, or is it okay to set up 2 or 3 appointments with different folks to go meet with them and discuss what their options are?
It varies. Some attorneys will charge for initial consults. Some have free initial consults. Some will charge, and then they will apply that fee towards the overall cost of the estate plan. If the client chooses to hire them. Even if you had to pay for each one of those consults, I think that investment, in my opinion, is a great use of funds, because again, you're doing this for a reason, and it's not an inexpensive process all the time. It's not expensive all the time. However, you're putting your time into this, and you want to make sure that you're doing it with the right person, because you have to partner up. You have to be able to answer a lot of questions that the attorney will have. And if your style and the attorney's style are very disparate, that's not going to work very well, and you're not going to get the best outcome or the best output.
This is a long-term relationship that you're developing. It's something that you're going to continue to grow with. So it's been very enlightening. Thank you so much for being with me today.
Thank you very much, Lisa. Thank you.
That wraps today's episode with practical, clear guidance on business law, probate, and estate planning with Meents Law. To learn more about Frank Meents and his team at Meents Law PC, please visit mentslaw.com. Thank you for listening, and be sure to like, subscribe, and share this episode with someone. We'll see you next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.